Number 6, cannabis and Second Amendment rights. Now, this next one is a absolute game changer that is flipping the ATF's playbook upside down. We need to talk about the intersection of the Second Amendment and cannabis use, specifically the landmark shift triggered by cases like United States versus Daniel. For over half a century, the federal government has used Question 21G on the Form 4473 as a trap. If you admitted to using a substance that is now legal for medicinal or recreational use in the vast majority of U.S. states, you were instantly branded a prohibited person and stripped of your right to self-defense for the rest of your natural life. But the courts are finally applying the history and tradition test established by the Bruen decision, and the government's argument is falling apart. The judges are looking back at the founding era and asking, where is the historical evidence that we ever permanently disarmed someone for using a substance that didn't involve violent crime? The answer is simple. It doesn't exist. This new legal reality means that the government can no longer justify a lifetime ban on firearm ownership based solely on the past use of a substance. Unless the state can prove that an individual is currently intoxicated and posing an immediate, tangible threat to public safety while holding a weapon, they have zero authority to infringe on that person's constitutional rights. This ruling is a massive victory for millions of Americans who have been forced to choose between their health or lifestyle and their ability to protect their families. It's forcing the Department of Justice to realize that illegal under a federal statute doesn't automatically mean unprotected under the Bill of Rights. This is a total restructuring of who the government is allowed to blacklist from the Second Amendment, and it is long overdue.